To start it out, many people think that they don't need an estate plan, or they're just apprehensive about starting the process because it kind of involves, thinking about death or bad things happening in life. But it's really important, we know, to have those documents lined up early in life. Can you start us off by telling us what are the common estate documents and give a brief overview of each?
Thanks, Alissa. Yes, I couldn't agree with you anymore. It is very important to have an estate plan. You need it to have asset protection. You need it to sometimes save estate taxes and costs. And most importantly, you need it to reduce the stress on your loved ones in the time when they need it the least. So it's a great idea to start at the beginning and just go over some of the basic estate planning documents that you do need to have in place. The first one I want to talk about are powers of attorney. And those are documents that you use during your lifetime. And if you have a power of attorney, then you name an agent. And your agent's the person that can act on your behalf. There's two kinds that we typically suggest. The first is a financial power of attorney, and the other is a healthcare power of attorney. Now, with your medical power of attorney, you generally also prepare a living will. And that living will, it's going to give your agent the instructions they need to make the decisions. So your living will usually sets out exactly what kind of healthcare decisions and healthcare you want in the event you can't advocate for yourself. So similar to agents under their power of attorney, you're going to name an executor, and that's the person that's going to be responsible for carrying out all your wishes. There's a lot more planning that can be done, but those are just some of the basic, most critical documents.
A term that commonly comes up in estate planning is probate, and it can be, more complicated in some states versus others. So another good reason to have a sound estate plan. Can you tell the audience what is probate?
It's the court supervised process that assets have to go through to take any asset from a person that passed to their beneficiaries. And it is different in each state, but the three primary steps that every probate goes through is number one, you have to file the will with the court. And your executor does that. It's the person you name to handle everything. Your executor has to go to a courthouse and present it to the court. And then next, that executor has to provide notice to all interested parties and to the general public. And then finally, the third step is you have to account for all of the assets for the person who died.
So if we want to avoid probate, trusts are often a frequently used solution. Can you break down the most commonly used trusts?
We often use something called a revocable trust to avoid probate. And first, it's important to understand that probate only applies to assets that are in an individual's name. So anytime you transfer assets out of an individual name, you can remove assets from their probate estate. And the easiest way to do that without losing any control over the assets is by creating a revocable trust. Revocable trusts are good for avoiding probate because you still control and benefit from those assets, but those assets are still includable in your taxable estate, and revocable trusts do nothing in terms of creditor protection or estate tax savings. If you were looking for more asset protection or estate tax savings, you'd have to create an irrevocable trust. And when you create an irrevocable trust, you select the terms of the trust, you name a trustee to carry out those terms, but after that, you have no say in what happens to those assets. And sometimes people assume that trusts are just for the ultra wealthy, but that's just not true. Trusts can be a wonderful way to pass assets to your beneficiaries because they offer asset protection. Not everyone needs a revocable trust to avoid probate. Remember, probate only applies to assets held in your sole name. So any kind of asset that you have jointly held, that's going to pass directly to your surviving joint owner. That skips probate entirely. And then also any asset that you have a beneficiary designation, and that's where you name a person that's getting the assets when you pass. And that's anything like a payable on death account or a life insurance policy or an IRA with a named beneficiary. None of those assets are subject to probate. They go straight to the beneficiaries.
So are these documents that we create, whether it's, a revocable trust or a will or a power of attorney, are they a one-time thing, or should they be reviewed often? If so, how often? And what are some of the common triggers that would come up throughout life that would, suggest it's a good time to review them?
Great. That's another great question. So your estate plan, as you're alluding to, it should evolve throughout your life. Anytime you have a major life event, such as the death of a loved one, a marriage, a birth of a child, you really do need to revisit your plan. So barring any significant life event, I'd suggest sitting down with your estate planning attorney maybe every 3 to 5 years to update those documents.
So lastly, what are some common estate planning mistakes that you see?
Well, I think the most common estate planning mistake I see, it's not really with the estate plan itself, but it's the communication of the plan. I think it's critical that you have discussions with your family regarding your plan during your life. So you don't really create an estate plan for yourself. You're doing it for your family. And it's to make things easier on your loved ones at what might be the most stressful and overwhelming time of their lives. So I think that's why it's so important that you sit down with your family and you review your estate plan with them.
If any of our viewers have questions, please reach out to us at sdwealthmanagement@schneiderdowns.com.
Thanks so much, Alissa.